Case number 255035 OD, the people of the city of Cadillac versus Alan Hernandez Cruz. Appearances, counsel.
Joanne, agree with people.
Robert Hartel from Mr. Hernandez Cruz, who joins me at the table, Your Honor.
And we are here for a pretrial. Is there any resolution?
Yes, it's my understanding the defendant will be guilty to an added count 2 operating while visibly impaired. People will dismiss count 1 operating while.
I believe there's also a civil infraction for a refusal to take a PBT. Is that part of the agreement at all?
Was not.
All right. Mr. Hartel, is that accurate?
It is, Your Honor. If I recall correctly, I did preemptively forward a copy of my client's assessment to the court as well.
I have received that.
Okay.
Sir, have you heard what the attorneys have said the resolution in this case is? And is that how you wish to resolve it? All right, will you please raise your right hand? As best as you can, do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Yes? All right, you may put your hand down. It's my understanding that you'll be pleading guilty to what is essentially an added count 2 of operating while visibly impaired. In exchange for that, that operating while visibly impaired is a 93-day misdemeanor, which means you could sit 93 days in jail and or a fine of $300. In exchange for that, the people will be dismissing the operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail with a fine of not more than $500. But there's some different licensing sanctions that go with your plea. Do you understand that?
Your Honor, if I may interrupt, I will dismiss the PBT review.
Okay. Additionally, the civil infraction for the refusal to take the PBT will be dismissed as well. Back on December 7th of 25, were you on probation or parole? Were you on bond? No. Do you remember reading and signing the advice of rights form and talk about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights? Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you in any way? No? I need you to say it. And is your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
Yeah.
No, Your Honor.
And Mr. Hernandez Cruz, the allegation that on or about December 7th, 2025 in the city of Cadillac in Wexford County, how do you plead to operating while visibly impaired? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on December 7th, were you in the city of Cadillac driving a motor vehicle? And prior to operating that motor vehicle, had you consumed alcohol? What is it that you'd had to drink?
2 beers.
All right. And did consuming those 2 beers visibly impair your ability to operate the motor vehicle?
No. Yeah.
Yes. All right. Do counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
I do.
As do I, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Sir, I find you guilty of operating while visibly impaired. Pursuant to the plea agreement, the operating while intoxicated will be dismissed. As already been mentioned, I've received the substance use assessment in this case. Ms. Carey, have you received that as well?
I did.
Do either party have any corrections to it?
I may have a brief one, Your Honor.
Jail.
Thank you, Your Honor. I just conferred with my client. There are no corrections.
All right, allocution then, Mr. Hartel?
Yes, Your Honor. I would ask the court to consider time served and then minimum fines and costs in this matter. As the court very likely recalls, my client does have an ice hold. He's aware that he's going to have to deal with that. There's a very high chance of deportation. I don't do those type of cases myself, so I haven't given him any legal advice in that regard, but I do wish him the best with it all the same. He has been lodged pending resolution of this case. I do believe time served would be appropriate. I don't believe probation would be doable, to be frank, because of the situation with ICE. I believe when it would be taken, it would be out of state, if I understand correctly. And I don't believe any additional jail is necessarily warranted for this exact situation. Thank you.
Thank you. Ms. Carey?
No elocution, thank you.
What brought him to the attention of law enforcement?
By the road facing west. Turn on 13th Street. Officer turned around, followed and stopped him for defective headlights.
Okay.
But said Mr. Allen pulled into a private driveway. The officer parked and waited, and then we came back out on 13th Street, and then was speeding 70 and 55.
All right. Well, Mr. Hernandez Cruz, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
No.
All right, well, as Mr. Hartel has indicated, the defendant has not been able to postpone because of the immigration hold. I have reviewed the substance use assessment. It indicates that he does not have a disorder. Ms. Carey, just out of curiosity, what was do we have a blood draw or?
0.14.
The defendant has 31 days jail credit, so the sentence today will be 31 days with 31 days credit. There is a $75 crime victims' rights fund fee, $50 state minimum fee. $200 fine, $150 court costs, $150 attorney fees. Is there any reimbursements requested, Ms. Carey?
Yes, to the city of Cadillac Police Department and the prosecutor's office.
$100 to the prosecutor. Was it a blood draw or breath?
Blood.
$300 to the city police department for the blood draw. Counsel, I believe that pursuant to MCL 780.73, I'm required to give 5 days, $5 credit for every day that he sat in jail towards his fine. So I hereby issue pursuant to that statute a credit in the amount of $155. Mr. Hernandez Cruz, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. And then because I have imposed jail, even though it's credit for time served, you do have the right to appeal that decision. And if you decided that you wanted to appeal it but could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. All right. Do you have any questions for me about your sentence?
No.
All right. You can go with the bailiff then. I'm sorry, counsel, anything else for the record?
No, thank you.
All right. You can go with the bailiff. Thank you. Person at the jail, please state your name for the record.
Todd Burns.
This is case number 253733 FT, the people of the state of Michigan versus Todd Allen Burns. We are here for an arraignment. Mr. Burns, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, Your Honor.
Did you also have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, Your Honor.
I have a complaint that alleges that between the dates of July 17th, 2025 and July 25th, 2025 in the city of Cadillac and Wexford County, it is alleged in count number 1 that you committed the offense of motor vehicle unlawful driving away. That is a felony punishable by up to 5 years in prison. Additionally, the prosecution has opted to charge you as a habitual 4th offender. That means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 5-year felony a 15-year felony. Do you understand those? I'm sorry, it makes that 5-year felony a life offense. Do you understand those charges and the potential penalties?
I understand what you said, Your Honor. Yeah.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to be have an attorney present during all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
As we have a request the help of Mr. Harrison, public defender.
Well, we can't guarantee it'll be Mr. Harrison, but we can make a referral to the public defender's office for the appointment of an attorney. So we will make that referral. We'll enter a not guilty plea on your behalf, and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause of the crime had occurred, and two, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. However, if they are able to do that, you'd be ordered to stand trial in circuit court. Part of the preliminary examination will be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel in 04, I show an operating while intoxicated, an attempted larceny in a building, in 07, a malicious destruction of property, in 13, an attempted assault and battery, in 16, a resist and obstruct and an OWI, in 18, actually two child abuse fours, an OWI third, and in 22, a driving license suspended and a highback second. Looks like he was released off probation on August 22nd of 24, and the praxis scores him at a risk level 2. Any comment regarding bond, Mr. Harrison?
Well, in addition to all of that, the fact that he was able to complete probation, he owns the house, the address that he provided. He is gainfully employed in a variety of jobs. He not only works at the Bourbon House, he has a real estate brokerage practice, and has substantial ties to the community. It's my understanding that the vehicle in question, there's a dispute as to the ownership of the same between Mr. Burns' former significant other and her new significant other. So it's not just your ordinary run-of-the-mill, found the vehicle and drove it away. The parties all know each other as far as I know. I don't see any risk in releasing him PR here, although it is a felony charge, as you've described, Your Honor. He's never shirked his responsibility for appearing in court. I believe he had one. I've represented him in his most recent case, and I believe he had one failure to appear, but it turned out that was due to a mix-up in the notice being sent to him, or some procedural difficulty, and we rectified that right away. Like I said, I think he's a good candidate for PR. Thank you.
Thank you, Ms. Lawrence.
Thank you, Your Honor. Mr. Harrison is right in the respect that this vehicle used to be owned by the defendant's ex-girlfriend. But in this case, that ex-girlfriend actually sold the vehicle to her current boyfriend. He had a title for the vehicle. I believe the defendant was aware that he did not own this vehicle. Police actually made several attempts to get in contact with Mr. Burns to retrieve the vehicle, and he essentially, for lack of a better term, evaded them for quite some time and refused to hand the keys over to the vehicle, which never belonged to him in the first place. I do think, given his criminal history, a small monetary bond may be appropriate, as well as this is a pretty high-level felony given the habitual fourth offender. So I would ask for some type of monetary bond. I would also ask for a no contact order with the victim. Thank you.
There is no contact.
My reading of the probable cause affidavit was that the vehicle was left at his house, and then in between time, the girlfriend deeded it or titled it to someone else, and then he drove it, and eventually it was abandoned in a parking lot. Am I correct on that?
Correct.
At least according to the probable cause.
Yeah, that's a skeletal version. That's
Your Honor, I mean, I've been paying my child support every week. My children really need me out there working so I can continue to pay my child support. All I do is work and go home, that's it. I came in here with a few $100s that I could bond out with if you allow it.
All right.
He does walk to work at the Bourbon House. I've seen him.
Ms. Lawrence, are you requesting a no contact with the new owner of the vehicle or Russell or the ex-girlfriend?
It would be Russell, Your Honor.
All right.
I don't speak to any of them.
All right, Mr. Burns, as a condition of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Russell Rondo. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Given the praxis scoring at a risk level 2, which is released with conditions and supervisions, I think we can meet that requirement with the no contact order. I'm also going to order that you enroll in community corrections services. I will release the defendant on a personal recognizance bond. Mr. Burns, before you are released from jail today, you'll be receiving your next court date. Make sure that you make note of that court date. And then you'll also need to come over here to the courthouse and get signed up for services through community corrections. All right.
Thank you, Your Honor.
All right. Thank you. Thank you, jail.